The High Court requires me to produce the child today without even giving me an opportunity to explain the circumstances. My lords, we have sent the email. I'm saying today, my lord. I'm not.
Today,
I cannot.
Monday, please. Monday. No, Monday.
My lords, there'll be NBW otherwise issued.
No, please. Please, give the
my
child.
lords,
Doesn't make a difference. The child can come back.
My lords, then keep it on Monday.
No, Monday. Monday.
I beg your pardon, my lord.
Monday.
Monday. Very well, ma'am. So I take that. Grateful, my lords.
Let's.
Yesterday as
Your Lordships. So all apologies.
when I say both of you.
Get to give a report to you.
I know. I saw that nobody has done anything.
Yes, we are supposed to respond after
Yes.
any files.
You have also not done.
I've not been able to.
Others have also. Sorry.
But can I do it by Monday?
Can you request at
Yeah,
2
Monday.
o'clock? Can you request at 2 o'clock? Because
because
the combination is different.
I know that. I thought I'll mention at 10:30 so that alert your Lordships.
No, we are already alerted. Unless we are on guard.
You will be here.
Please mention at 2 o'clock so that we can find out something.
Very, very.
The mediation report, because I understand if it goes to the registry, matter on 23rd, and if we have to hold a meeting or two is made, they can, so either your lordships may, if they can make it available today, or not, I can also request a mediation, we would be happy to share, but I thought I'd pay the cost.
No, we have already directed, so you can have it, Nisha.
It takes 3 days by the time it goes to the registry.
No, just get a copy and serve them. Ask the registry.
I'm grateful.
Yes.
With your Lordship's permission, may I mention a matter which is likely to be listed on 21st?
In that matter, I'm appealing on behalf of the state of.
Please mention on 21st. As and when the matter is listed. No, we don't allow that.
Tell my personal difficulty because 20.
Let somebody remain present on your behalf and make requests.
Just tell your lordship, I'm undergoing a medical procedure on that day. Therefore, I was speaking that the other side is to be seen. I've informed them. I'm in personal difficulties for 2 weeks.
It's difficult to remember the matters like this that you mentioned.
Memo, if I can just pass it on to the postmaster. This is the matter where I'm seeing.
You may-
2 weeks.
Let somebody remain present. Yeah, some colleague. We always accommodate when there's medical emergency.
Item 1. Shown to my lord's last order, my lord. I filed an application on the 14th of April. I have sent out, my lords, the complete record of the entire report. I have actually said that on the 18th of May 2022, actually the trial court took cognizance and then issued summons. Then thereafter, my lords, there was a stay by the High Court in 2024. And the fact that the presiding officer was transferred, that is reflected, my lords, from page 10 onwards. I will have page 10. On top of the page, my lords, 20th of December 2023, complaint filed so maybe, also sole accused is absent, presiding officer is transferred.
0.97%
Can't be
of
held.
what we are. This is only because, my lord, of gross undervaluation by the resolution professional. Corporate debtor is given for 826 crores, my lord, just 2 months after.
We are not going.
Just 1 point, my lord, just 1 point. Just 2 months after the new management takes over, they pass a board resolution to sell assets worth 3,000 crores. They get it for 800 crores and they're selling it for 3,000 crores. This indicates the gross undervaluation.
Sorry, they have to also implement the project. Right now, we do not find any good ground and reason to interfere with the impugned judgment and hence special petition is dismissed. Hence the appeal is. Yes, please.
Matter was passed on the basis of the judgment passed in the Jharkhand Urja Vikas Nigam Limited, which your lordship have referred.
No, please,
I will not
let
comment.
me put it. We have already referred that matter to a larger bench. One.
My lord,
And
kindly,
the award itself deserves to be set aside.
my lord, kindly
No.
attach my matter along with their matter. My lord, kindly attach my matter.
Sorry, this is sham, absolutely sham. We are not inclined to interfere with the impugned judgment.
My lord, what the same issue is involved.
Maybe the facts are too glaring. We are not inclined to interfere with the impugned judgment and hence specially petition is dismissed. We don't say anything. How much is the delay?
No,
So what will that do it file the review?
No, my lord, that delay was wrongly calculated, my lord. Only 85 days delay is there.
There is substantial delay.
No, my lord, there's only 85 days delay is there. That was wrongly noted, my lord. I have pointed
65
out
days.
their details.
You are also
Yes.
challenging the single judge's order straight away before us because your writ appeal was dismissed on the ground of delay. That's 385 days.
My lord,
Including that,
that
it's
delay was
564 days against the single judge's order.
Your lord.
There is substantial delay.
Single
at different
order was
stages.
passed on the
Just
Jharkhand.
listen. There's substantial delay on the part of the petitioner at different stages in pursuing the litigation, including filing of the present special petition. Full stop. Even otherwise, on merits, we are not inclined to exercise our power under Article 136 of the Constitution of India. Full stop. Accordingly, the special petition is dismissed. We clarify, question of law is left open. Next case.
My lord, kindly direct to be the MSME. It was remanded to the MSME to be take up the hearing because
Please go there and do that. That will be fair on your part, go there and do that. You start the conciliation proceedings. Conciliation proceedings do not result in a finding or any settlement. Within 3 days, you pass an award without taking any counterclaim, claim, anything on record. And this is not complete, not speaking order.
My lord,
And
kindly,
such an order will be even struck down, even in execution. Sorry, next case, please.
my lord, kindly see the.
Sorry, next
the
case.
Award of the award, kindly see the award, you will come to the page one.
We have seen that.
My lord,
Next
my
case.
humble request is to come to page 145.
Please, we have discussed it. That's it. Next case.
My lord, kindly direct to be the MSME to be.
Please move there. Please move there. MSME
They are my lord, but they are not
It
taking.
is open to the petitioner to move to the council for disposal, for decision of the arbitration case in accordance with law. What is the arbitration clause?
The arbitration clause is at page number 23. That's the amended clause.
Does the International Chamber of Chamber of Commerce and Industry in Mumbai have an international commercial arbitration tribunal?
Well, it doesn't refer to the, I'll have to find out, but this doesn't refer to the international chamber in
So
Mumbai.
please come to page 51.
Yes, Manoj.
Page 42. Page 42, clause 10, arbitration clause.
That
Should be settled in the International Arbitration Tribunal in the Chamber of Commerce and Industry in Mumbai. What do you mean? It doesn't say so.
This was amended. Can I see the amended?
Which is the amended clause?
That's at page number 23. Starts at 22.
Yes.
Then at 23. Clause 10.1 of the contract should be worded as follows. The parties will take all measures to resolve all disputes, controversies which may arise out of or in connection with this contract by negotiations. All unsettled controversies arising out of or in connection with the present contract should be settled in International Commercial Arbitration Court at the location of the applicant. It's not happily worded, my lords.
The law of which country is applicable?
Law of India.
Next, below that, my lords, the contract comes into force from the date of signing. The terms of the contract regarding payment guarantees are valid so and so. But now the amended clause does not disclose which law will be applicable.
So what you have not amended says
It
substantive
says
law of
Indian
India
law.
applies.
It says Indian law.
That says Indian law.
That says Indian substantive law of India.
Clause 10.2 has not been amended.
10.2 is not amended.
When it comes for the petitioner states that the amended clause 10.2,
So that 10.2 is also worded as
Sorry, my lords,
follows.
10.2 is amended.
what does it say?
But you've not
It is silent
referred
from
to what the governing.
substantive law.
Where was the agreement signed?
The agreement was signed in Russia. However, my lords, the place of the arbitration would be on the basis which party invokes. I am the first party to invoke. After I invoke, my lords, in fact, there is also an order, my lords. There is also the Bombay High Court in Section 9 has restrained the respondents from instituting any arbitration proceedings or continuing with any proceedings.
How can that be?
Lords,
1 minute. How can Bombay High Court do that?
what happened is,
Then 1 minute, please. It's a anti-suit injunction
yes, my lords.
or anti-arbitration injunction.
Surviving is
Expression of
because it is,
subscribed. What do you have to say?
your lordships have already protected him, your lordships, and he's cooperating in the trial court, your lordships. All. And the complainant is not even appearing here, your lordships.
It is not our business. That is,
I would only beseech my lord, just confirm this order, my lords, the whole matter would come to an end.
no. Read.
My lord's order of 12th of November 2024.
No, why did you not appear earlier?
Well,
Pursuant to the
that's
summons
because
of-
I had moved the High Court, my lords, and then High Court protected me. High Court had protected me, and subsequently, my lords, when the High Court rejected the anticipatory, I moved this immediately, I moved this court.
Even if you were protected, it was your duty to just inform the
Yes, my lords.
trial court and then
I'm not saying, my lords, but ever since, my lords, after that, my lords, complainant is not appearing, my lords, no headway is taking place, and my lords, the presiding officer stands answered, nothing is moving. And therefore, under these circumstances, that's why, my lords, I actually got all the orders of the trial court, my lords. I got all the orders, in fact, my lords, attached along with the affidavit, my lords, the additional affidavit. So therefore, my lords, I beseech my lords, kindly, in fact, protect me so far as this order which my lords have passed while issuing notice. And then, my lords, the trial, I am cooperating in the trial, my lords. I am cooperating wherever the dates are fixed. Not a single date, my lords, I have been absent thereafter.
No, your presence is also not noted.
Yes, my lords, it's noted, my lords, everywhere. Kindly see, my lords, the last 3 orders at page 12 onwards. 2nd January 2025, sole accused files Azri. Then, my lords, 6/1/2025, again I am present. Then, my lords, on 11/2/2025, I am present. Then, my lords, on 3/3/2025, I am present. Then, my lords, on 28/3/2025, I am present. Kindly see the last order, my lords. It's very clear, my lords.
Okay. 98. The complainant?
No, your lordships.
Please update it.
He is not appearing in the trial court as well as Supreme Court.
Is she served? Is she served?
Yes, my lords. In fact, the second respondent, my lord. Yes.
Leave granted. The appeal is directed against the appeal order dated so and so passed by the High Court of Judicature Act.
Possibly the citus may be Russia. We are not commenting about it. We are commenting about it, but not pronouncing on it. But you'll have to check up the case law.
You consciously remove the governing law being Indian law. You removed that.
It was removed.
There needs to be some implication to that also.
It was perhaps not intended based on which party is aggrieved. That's why, my lords. I follow what is calling from your lordship.
That will have to be examined.
Yes.
That will have to be examined.
Obliged. Please, yes, my lords, we have already circulated a letter in this regard.
There is substantial delay in preferring the present special petition. Even otherwise, we are not inclined to interfere with the appeal order. Hence, the special petition is dismissed on the ground of delay as well. Hence, the application for condemnation of delay and the special petition are dismissed.
Obliged.
You pleaded chief of army staff and whatnot.
They were the parties in the original petition. I'm not interested actually, sir.
Not this.
Even if the ASG comes and says we'll pay, I'll be happy.
Go for the jugular, things might start functioning.
I don't want to go. I saw that we don't want to involve them at all.
You could have impleted this Sharwan Ram who writes this letter.
That's all. If you have not impleted him, have you? You're not, and you have to implead people by name. You can't implead like that. In contempt. I don't know how they have
allowed it.
Yes.
May I request, Lord, if the...
Oh, no, you have impleaded them by name.
And agrees to...
And are not impleaded the right person.
The people are the same as the...
No, I know, but then...
The names should come.
No, names are there. Names are there. I saw the wrong memo, probably the memo parties as it was in the original petition.
I don't want to trouble anybody, my lord, and somebody can come and tell your lordship and settle the matter.
Issue notice, returnable to the week commencing 13th of May 2025, notice to be served by all modes including Basti. Stop. We clarify notice that respondents need not appear in person. Stop. I need not appear in person as stop. Further, the petitioner is directed to plead. That's a PIO. Plead. What's the name of the Lieutenant Colonel? Name is Dr. No, this. Okay, why copy? To plead. Shravan Ram, Lieutenant Colonel Shravan Ram, who had written the letter dated 5th October 2024 to the present petition. Stop. Notice will be served by all modes, including trustee.
This will not translate.
When was the order passed by us?
20th of March last year.
Last year.
Great. May I please
There's no assurance given. It's a statement made in the court. How can it lie?
Yes, my lord.
Contempt will not lie.
My lord, just bear me for a few minutes.
How will contempt lie, please? It's not a direction given by or an undertaking
There
given
was
to
a
the
direction,
court.
my lord.
It's not a direction, sorry, you're wrong.
My lord, I'll read the direction.
Read that direction.
I'll read that direction. Your lordship may just have a look at, my lord.
I've read it. It's a statement made that they will. It's a statement made which we have accepted, taken it on record.